All right, so what does today's Supreme Court decision mean for Florida and for the state of Georgia? Kent Justice is joining us now with some insight. Kent?
Yeah, thank you, Tarek. So we're joined by State Senator Audrey Gibson and government law attorney Chris Hand. It's okay to have water with you for a moment. It's fine, Senator. But Chris, lead us off here as we talk about this. This went to the Supreme Court because of a case out of Mississippi, but the ruling today affects everyone in America.
Well, Ken, I think we actually have to go back almost 50 years to 1973 when the Supreme Court, in the case of Roe v. Wade, decided that a woman's decision whether or not to have an abortion was protected by a fundamental right of privacy in the United States. That decision was upheld and modified in the decision of Casey versus Planned Parenthood in the late 80s, early 90s. And in that time, since then, there have been a variety of challenges to that law. The Mississippi law, which was one that imposed a 15-week restriction on when abortions could be performed, down from the 24-week standard that was in Roe v. Wade, and that Casey decision, that ultimately worked its way up to the Supreme Court, was heard by the court this year and resulted in today's decision, which didn't just uphold the Mississippi law, but as you say, actually overturned Roe v. Wade, overturned that fundamental right of privacy as it relates to a woman's health decision to have an abortion, and has now returned that issue to state governments to make the decision as to what the policy in each individual state is going to be.
Chris, you've got extensive experience as a government law attorney, also working for U.S. Senator Bob Graham. But you mentioned states' rights. State Senator Audrey Gibson. So this is something that both sides argue that the judicial branch is to interpret law, not make policy. State lawmakers, and especially now, we're saying this issue of abortion goes back to the states. So help us understand this. Florida recently passed this law that makes abortion illegal after 15 weeks. That goes into effect a week from today. Do you think that this changes? Will abortion be an issue that's settled in Florida, or is this something where the state legislature could go even farther now?
Well, thank you, Ken. And let me first say that the decision today is really an assault on the right to access to health care for women and a woman's right to make up her own mind without pressure and in private. And so in terms of the how this impacts the states, of course, we've seen that individual states have already, including Florida, as you mentioned, started to make abortion laws or a partial ban on abortion. And so when you think about the 50 states, and every single state could have a different policy. Some states may say it's so many weeks, or you may not have an abortion at all, or access to those services. And so I believe that the Supreme Court certainly did an injustice to women, because if you have to travel across country to access the service, that is not acceptable. And it certainly is not the way that a woman making her own decision should be treated.
Before we run out of time, I want both of you to weigh on this. Let me point out, in Georgia, by the way, a law making abortions illegal after 6 weeks of pregnancy. That was signed in 2019. Wasn't in effect because of legal challenges, so we're monitoring that. But this privacy issue, so again, I want both of you to weigh on this. What about a person's privacy rights? Because in Florida, the state has its own right to privacy article in the state constitution, but we're also seeing that HIPAA is not covered in the event of a court order. So what if someone wanted to take a look at a medical record of a woman to determine if that fetus was a certain age and whether or not that abortion was okay?
Well, Ken, I think that's going to be one of the key legal questions moving forward, is that constitutional right to privacy in Florida. Let's remember that one of the key points in that decision today was that this, to quote Justice Alito, this matter is being returned to the people and their elected representatives. Well, the people of Florida in the last 40 years have spoken on this issue several times. In 1980, they overwhelmingly passed the constitutional right of privacy that's in Article 1, Section 23 of the Florida Constitution, that prohibits unreasonable interference in the private lives of citizens. In 2012, citizens defeated an effort to limit that constitutional right to privacy when it comes to the issue of abortion. So there are already 2 lawsuits filed against the action that the legislature took this year to narrow abortion rights. Those lawsuits will focus very much on that constitutional right to privacy and whether that previous speaking by the people of Florida has an impact on this issue.
Yeah, Senator, 30 seconds or so on what privacy we could see that happen here in Florida, what goes on?
Well, we'll see what happens. Hopefully we don't get called back to a special session or anything like that, but privacy is privacy. When you go to the doctor, and by the way, Florida is one of 8 states that 20% of African American women don't have access to health care, and brown women are just underneath that. But when you go to see your physician, he doesn't see you in the waiting room where everyone can see what's happening, right? He sees you in private. And every woman is entitled to access to health care in private.
All right, State Senator Audrey Gibson, Chris Hand, government law attorney, appreciate your insights today.